Yes, a second wife can claim maintenance from her husband under the Hindu Adoptions and Maintenance Act, 1956, even if her marriage was illegal. However, the Supreme Court ruled in the case of Yamunabai v. Anantrao that the second wife must prove that she is legally wedded to claim maintenance under Section 125 of the Criminal Procedure Code, CrPC. Here are some other legal provisions related to second marriages. 1. Hindu Marriage Act, 1955. A second marriage is illegal if the first marriage is not legally finalized. 2. Section 488 of CrPC. Only legally married women are entitled to maintenance under this section. 3. Section 494 of IPC. Bigamy is a punishable crime under this section. However, the Supreme Court ruled in Dr. Suraj Stella Kujur vs. Durga Charan Hansdah that a second marriage is not bigamy if it is allowed by the custom or law governing the parties. And 4. Children from the second marriage. Children from the second marriage are considered legitimate and have the same rights to their father's property as children from the first marriage. In the 1988 case, Yamunabai Anantrao Adhav AVS Ranantrao Shivram Adhav, the Supreme Court ruled that a marriage between a woman and a man who is already married is null and void, and the woman is not entitled to maintenance under Section 125 of the Code of Criminal Procedure. 1. The marriage is null and void under Section 11 of the Hindu Marriage Act, HMA. 2. The woman is not entitled to maintenance under Section 125 of the Code of Criminal Procedure. 3. The magistrate dealing with the application for maintenance does not need to determine if the woman is entitled to maintenance under any other act. And 4. The provisions of Section 125 of the Code of Criminal Procedure and Section 488 of the Old Code are secular in nature and are different from other acts, such as Section 25 of the Hindu Marriage Act.